Take it.
Red X, sir. State your name.
Anthony Joseph Davis.
Mr. Davis, you're fully court on a fugitive from justice warrant out of the state of Pennsylvania. Do you understand that, sir?
Yes, sir. I've seen it. I'm gonna have to plead that's not me, and I wasn't in the state at the time of the crime, Your Honor.
Okay. Are you the Anthony Joseph Davis that Pensacola, or Pensacola, you wish, I wish, that Pennsylvania is looking for?
No, sir. I don't believe so. I got the wrong one.
Well, then you can sit on dead time and have them go through the process of getting a governor's warrant to get you back up there, or you can sign a waiver of extradition, putting them on the clock to come get you.
You can make them go get a governor's warrant.
That's outstanding. All right, I'm going to have you returnable to a first appearance judge here in Bay County if you haven't already been transported before December the 11th.
And if they don't have it by then, I'll be on the ball, won't I?
No, you'll just be waiting for them to see if they're going to really do it.
Well, they got time constraints to get the warrant, ain't it? 30, 60 days, something like that?
Kind of, but not really. No.
Who is this, Judge Van, or I'm sorry,
Ban.
I'm just asking. Yeah, I was just asking because I had to deal with my local court cases where you dismissed them or transferred them to the other court. I fought extradition one time before, Your Honor. That's why I was asking. It wasn't no sign of disrespect or nothing like that.
It's fine.
All right.
I'm just telling you, as long as they tell us they're in the process, that time limit doesn't really mean a lot.
Let me ask you this, Judge, and I'd ask you to take judicial notice, if you will, of this. The detainer, the NCIC, it says in the remarks section that this warrant's not only good within 250 miles of the state. I've been going through this with Walton.
I wish they would tell us that they don't want you. If they would tell us they don't want you, we'd let you go because you're costing us money.
How do I get the teletype from the actual NCIC? Because I had it once before because we were having an issue about who gave me the teletype in Walton County. I know I'm not supposed to have it because it's an interagency.
Right. You're not supposed to have it.
Right, but I did have it, and it said in real fine remarks section, will not extradite if it wasn't within 250 miles. And I'm quite sure it's still.
And if this is just me spitballing, if it was me, and I kept getting picked up on the same warrant, and kept doing 60 days or 90 days, or
you know what, you're right.
I'm just asking,
where I signed the waiver at.
I would probably go to Pennsylvania and tell them.
Waiver, I'm going to sign it.
She's got 6 copies.
You got to feel hard at the end, Judge.
But I mean,
where I need to.
Wouldn't you want to get it? Wouldn't you want to scratch the itch? Get it done?
Yeah, I'm going to scratch the itch just because it's you.
Yeah. 1 month. I mean, that's just me. I kept getting picked up on the same thing.
Yeah, it's 5 of them.
5 of them.
Yep.
5 copies. Because everybody's got to get an original.
So how many days do they got to come get me now?
30.
All right. That's.
See? I can't give you legal advice, but you actually read between the lines pretty well.
Y'all let him get away?
Let me go see if he went back in our office, Judge.
I thought the DA's office was doing a better job of controlling him lately. No, okay. How about you, John? Well, why don't we go?
He's coming right now. You're not here with Miss Ellie back there. He's coming. Yeah, what am I?
Can't y'all get a GPS on him or something? Because you tried to escape. We heard you. We leaving. We locked all the doors, and you came back, didn't you?
Not like mold in the shower. It's hard to get rid of.
There's another part to that saying too, but I'm not going to say.
Yes, sir.
Oh. All right. In all seriousness. We have a case here that I've remembered, see, I've looked at this.
Yes.
Which isn't good. All right, we call 23 CR 949, the state of Texas versus Americo Cavazos, who's present with his attorney and the state's attorney. In this case, Mr. Rojas, as the defendant's attorney, has fashioned with the DA's office an agreement where the defendant has pleaded guilty earlier to the indictment. And in the indictment, he pleaded guilty to paragraph 1, which alleged that on or about October 2nd, 2022 in Jefferson County, Texas, he was operating a motor vehicle in a public place while intoxicated. And it was actually like 3 times the level too, which is of intoxication, according to the test of his sobriety. And that he has 3 prior convictions of DWIs, 1 out of the district court of Hidalgo, which is misspelled in the indictment, but I think it's close enough. I don't think we need to tamper with it, but there is no Hidalgo County. It's Hidalgo County, Texas. And that was in 2007. 2018, a conviction, as well as 2019 convictions in Marion County, Indiana, of DWIs. So this is not his 3rd, this is your 4th that we know of. So you pleaded true to paragraphs 1 and 2, which constitute the 3rd-degree felony of operating a motor vehicle while intoxicated. And this is the 3rd or more conviction. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Or are there any corrections or changes to it?
None from the defense, Your Honor.
None, Your Honor.
It's then, without objection, it's made a part of the record for all purposes. What the agreement here is whatever sentence shall not exceed a cap of 7 years in prison. So he is looking at no less than 2 nor more than 7 years in prison. He can be sentenced up to no less than 2 nor more than 7 years confinement in prison. And then that could be suspended and it could be placed on regular probation. Deferred or unadjudicated probation is not an option. So those are our options, correct?
Yes, sir.
Anybody add anything else? All right, a couple of things I'm going to want the parties to help me with. Number one, this pre-sentence report reflects that a blood warrant was issued and the defendant, according to his the execution of that blood warrant of his system, it showed that his blood alcohol was 0.234. So that's literally right at 3 times over the legal limit of sobriety. That his statement was, I had maybe 2 beers with my buddy, and unless those beers were 64 ounces each, that's hard to get 2 beers to be, that's just not honest. You've got convictions of back to 93. We're talking 30 years now. False report to a police officer, and that was a misdemeanor. Operating a motor vehicle while intoxicated in 2002. Failing to identify in 2007, you get 28 months in jail on that one. That was a misdemeanor, obviously. a DWI in 2012 where you were sentenced to 1 year and placed on probation. That was revoked and you ended up doing 80 days in jail. Criminal mischief in 2016, that was 4 days in jail. That had to be a Class C misdemeanor, I guess, handled that way. Resisting arrest. And it looks like that must have been maybe deferred probation in 16. Then you've got a 2005 driving while intoxicated with a child passenger, which is not reflected in the indictments paragraph 2, but it shows under 15 years of age, you were placed on regular probation for 3 years. Illegal possession of a controlled substance in 2012, 4 years probation. DWI in 2016, you get 2 years in prison for that. Then these two Marion County, Indiana cases, which are alleged are not showing up in the pre-sentence report. What do we know about that? Is there any additional information that the court can be supplied? Anyways, while the state's looking into that, the pre-sentence report, it reflects that the defendant was given a urinalysis when he reported for the substance abuse assessment. He tested positive for alcohol with a blood alcohol of almost intoxication level, 0.071. He reports a 31-year history of alcohol use. 25 of those years he drinks to intoxication. The probation office states the defendant, I'm sorry. The person who administered the substance abuse assessment, Ms. Posing, states that her analysis is that the defendant is in denial of his addiction and attempts to rationalize and minimize his consumption of alcohol. He did not take responsibility for his actions and stated that he just does not want to go to jail. Tell me something I don't know. Everybody should be thinking that, or else that's weird. And she's recommending the defendant enter a structured treatment program with intensive outpatient treatment. So probation office is suggesting that he be placed on probation. Again, which hasn't worked in the past to prevent him from. And the last time he had this is, so in 13, we put him on probation. But that was revoked. The next time in 16, he gets 2 years TDC. And then these two Marion County, I don't know.
I'm prepared to give you some detail,
Okay.
Judge, if you'd
Thank
like.
you. Yes, sir.
On the first offense from Marion County, the date of that offense was October 19, 2017. He was sentenced in February of 2018. They title that as operating a vehicle while intoxicating, endangering a person. He was sentenced to 365 days, but it was suspended for 357 days. He had apparently
Probated for how long? That's odd.
it went from 365 to suspended for 357. Apparently he had 4 days credit and was required to do 4 additional days.
Okay.
Driver's license under those orders was suspended for 90 days. Looks like they had general conditions of probation similar to what we would do in that regard, Judge.
What year was that again?
That was, the offense date is October of 2017.
Okay, that was the
Sentenced-
2018 conviction.
Sentenced in 2018.
Okay, and then the 19.
The second offense from over there, his offense date is January 26th of 2019. Sentenced later that year, November 14th of 2019. Has the same title for their offense, the endangering a person classification. Additional offense noted there was carrying a handgun. He was sentenced to 545 days, and that was suspended for 180 days.
Yeah, I just don't understand it. I don't understand the logic of that at all. Turns right around, commits the same offense. They just don't seem, from the way they treated this, that's not taken seriously up there. I mean, this was subsequent to all the other, those are his most recent problems.
Yes, sir. What I'm referencing obviously has been provided to defense counsel in discovery. I've got certified copies of those documents if the court would like to see it, but that's a quick summation of that.
Right. I guess that's why I live here, not up there. That's just, and seems handling that unreasonably light. It's because what we're talking about is the irresponsible use of a 4,000 pound missile. I have people in here who family members have been killed by intoxicated drivers' actions. And I can't give them any relief. But it continues to happen. It's not a problem. It's not the consumption of alcohol, as long as it's responsibly handled by the person. But how many times do you have to get called with a DWI? Plus a lot of other problems here, but you just, the point is that it's a very selfish act. When you get in a vehicle and drive irresponsibly, it's the other people who are harm's way. And I can guarantee you, when there's a bad thing happens, nobody feels sorry for the person who was the perpetrator, the one who was the wrongdoer. They feel sorry for everybody else who was following the rules, who would sometimes their next life second is gone. And they were just minding their own business, and trouble found them. But you and others who like you are the troublemakers. But we have this over and over again, and everybody is aware that it's a problem. Everybody's aware that it can cause massive tragedy, but yet it continues to happen. But we've got to follow the rules, and we got to protect other people too. And think of others first. But the DWI is a selfish act. It's an act of selfishness. You know, it's an act of, I don't care about anyone else. That's just not right. We're supposed to be living together peaceably. Anyway, continue.
You'd like to hear from me first, Judge?
Yes, sir.
All right. You know, I agree with Detective Mark Bloom on this. It's time for this man to be incarcerated. His statements that he felt like he was coming from Houston and ended up on Main Street in Groves is very concerning. The fact that he's had said 2 beers, as you noted, Judge, I wanted to highlight for a moment because it's connects with a couple of things. This offense date is October of 22. On page 4, we note that he reports to them that his date of last use of alcohol was February of 2024. Not that he didn't stop after this incident, but he gives us this date of February 2024. And as Your Honor noted, that's not true either, because on the top of page 5 and what you've already noted for the record, he shows up almost intoxicated for the time of which to do his substance abuse assessment. Ironically, he tells Miss Posey that it was the night before that he drank 2 40-ounce beers. That contradicts what apparently he told her before, that his last drink was in February. She says he didn't take this responsibly, he just doesn't want to go to jail. I think that's just the first of everything. And to some degree, I know he's going to stand here and ask you for probation, but what lesson are we teaching him? I don't want to be like Marion, Indiana, and give him these opportunities. Every opportunity we've given him, he's failed at. The reality is, when he was arrested here in October of 22, he should have stopped drinking then, or he should have started seeking help then. It's not like he didn't know every other time that he's ever been arrested for all these type of things that he should have done something differently. And instead, what he does is he drinks right before he shows up for the substance abuse assessment. Every action this man says is screaming, please throw me in jail. I suggest 7 years TDC.
Go ahead.
Judge,
Mr.
I
Roberts.
agree, this is screaming for something, it's screaming for help, Judge. This man's been drinking alcohol for 31 years, according to 25 of those years he drinks to intoxication. Part of the reason he needs help is because he's in denial. I mean, he's in denial, he needs help. I think we can send him to prison for 7 years, and there's help classes he can take in prison. It's not going to be supervised by anybody, Judge. If he wants to do that, he's going to be able to do it. If he doesn't, he's not going to do it. If he's on probation, the probation department is going to be able to follow him monthly, make sure he goes to the classes, gets the counseling he needs. And for the first part of that, if you follow the recommendation of Ms. Posey, he's going to be inpatient treatment, or incarcerated with ISF for at least 90 days and come out and do some outpatient treatment. And certainly the court has other options available to him for safety, if that's something the court wants to consider. Despite his use of alcohol and dependence on alcohol, he has shown an ability. I think he's got 2 prior felony probations that he was able to complete successfully. He's held down a job. He's a supervisor, foreman for as a pipe fitter. He's able to function. He does have a role in society to play. He's asking the board to give him a chance and get supervised help, supervised treatment that he's never gotten before. And certainly Mr. Ham is correct. He could have gotten this on his own at any time after any of those previous.
Yeah, he sounds like a smart guy.
And like I said, just sometimes we just need a push, somebody there to hold our hand. And I understand that's not probation's job to hold anybody's hand, but I don't think this is one of the people that we just send to prison because he does have something to offer to society. He's able to hold down a job while using alcohol. If we can get him off of alcohol, Judge, I think he'd be a tremendously productive citizen.
But haven't we dealt with him on probation as early on this type of behavior in, well, let's see, 2007?
But I don't think he's been to ISF. I don't think he's been to safety.
What? Okay. Okay, so 2007, so we're going, well, I think I'm not sure why this indictment says that, because I have a 2004 charge, which was disposed of in 2005 out of Hidalgo County, of driving while intoxicated with a child under 15, by the way.
Your Honor, that is this particular offense that's listed here. That is the offense date is December of 2004. The date of that judgment is August 8th, 2007.
Okay, so that's reflected in paragraph 2 is the first of the
Yes, sir. He received 180 days state jail time on that August 8th date. Prior to that, he had received
So you.
probation,
the
but
defendant
he
pleaded-
didn't complete the probation.
The defendant pleaded true to that paragraph to the prior convictions of 2007 Hidalgo County that we are looking at reflected as the 2005 disposition in the pre-sentence report of a felony history where he was placed on 3 years regular probation. He was found guilty, placed on probation.
That is correct, Judge. That is when he was placed on probation, is that June date?
So
It ends
we're
up-
going on 20 years here.
Yes, sir.
So almost 20 years ago, he was given the chance, and this was that's just not, my God, was this your child? Was with you? It says DWI with a child under 15. Is that your child? You're mumbling. I can't hear you.
It was my wife and we went to eat because it was my birthday.
So what? So everybody has, puts in harm's way and gets killed on your birthday. That would be a terrible, tragic thing for that event date, huh? You celebrate your birthday by putting everybody in harm's way. My God. And a child. How old was the child?
14.
I can't imagine putting myself into this situation, but my own child. But we're looking at this rich criminal history that shows drinking is not really important to you. You have never come to appreciate it as being a threat to the security of anyone. When you're arrested, put in prison, none of those things make a difference to you. It doesn't seem to impress you that, if this is important, people are taking this seriously. But you still put your family in harm's way and yourself. So you got back in 20 years ago, and you go to prison for it. So in 2016, so it's serious, in spite of the fact that in Indiana, you were treated apparently lightly there for whatever reason, we don't know. But it's the circumstances I'm not certain about. But I'm counting one. Operating a motor vehicle by intoxicated. This has been going on since 2002. So you had one misdemeanor in 2002 of driving while intoxicated. One misdemeanor in 2013. It looks like a misdemeanor where you were sentenced to 1 year to 354 days in jail, however they came up with that, probated for 1 year, but yet in well, that doesn't make any sense either, because it says it was revoked in 2016, which would have been 3 years later, but you were only placed on 1 year probation. Or I don't understand. That doesn't make any sense. Does it to y'all?
It didn't, Judge.
So, but you were ultimately revoked and sentenced to 80 days in jail. So then we have the 3 other felony DWIs. So this is true. This is the 6th DWI, correct? You've got 3 felony convictions and 2 misdemeanors. This is what the pre-sentence. Weren't you placed on regular probation or you were found guilty of a misdemeanor operating a motor vehicle while intoxicated in 2002 in Marion County, Indiana. That's what this says. Y'all said it was right. Nobody objected.
No, there are judgments to
He
that.
says no. He's shaking his head no.
In 2018 and 19 in Marion. I have a son over there with the same name. But I mean, I've never been there.
Well, speak up during the hearing when everybody said it was correct. Now you're saying after this had get out of your coma here. Come on. You've got to speak up so we know if something's right or wrong. The fourth entry under misdemeanor court history, operating a vehicle while intoxicated, pleaded guilty. September of 2002, Marion County. That's right or wrong?
That's right.
That's right.
Yes.
Okay, this is getting more confusing. Now it's correct.
2018, 2019, no.
Stand by. 2019. What are we talking about? 2019. Where did that come?
He's referencing the two Marion County, Indiana matters. The ones that I was
Oh,
giving
in
the detail to you.
2018,
Yes, sir.
2019. It's showing.
If he's got a son with the same name, it's possible that that may not be him. I'm looking at the case summaries there. There's a Americo Cavazos Jr. And the picture looks like it could be his son, yeah. Based on the date of birth, I would have to agree with that.
Is that right?
Today was the first time I've heard somebody say that that wasn't him. And again, looking at these judgments, looking at the pictures, looking at the date of birth, him stating today that his son has the same name, I believe that that's his son.
Do you have a copy of?
As I stated, Judge, both these judgments were uploaded into Discovery and were part of the process before we did the plea.
Well, it says a birth date of 2/16/99. That's not your birthday.
No, sir.
That's your son's birthday.
Yes, sir.
So.
And
So-
I think the best suggestion is that we set this plea aside and give the attorneys an opportunity to correct an obvious mistake here.
I agree, Judge. I think there are sufficient prior convictions. I think we probably need to clean up the indictment and list the correct and previous priors in there so that we can make this a clean plea.
All right.
I will need to do some research into this DWI from 2012 and obtain that for us to do it. So if you'll, at this stage, Your Honor, I would just ask
Okay.
To abate these proceedings for now and give me an opportunity to do that.
Mr. Cavazos, we're going to reset this case for later. But I think it can't, we can't end this hearing without at least acknowledging you've got an issue here. But what's worst is your legacy has been passed to your son. Now, he has 2 prior DWIs. Where did he learn?
I can tell you that.
That's your gift to him, is setting a bad example. Well, now your son,
I haven't seen him in 21 years. So
don't blame dad. Or maybe that is a problem. But whose fault is that? Oh. You got more problems than just those criminal. You got family that you're supposed to be the head of the family. And it's gone off in the wrong direction
Yes.
with you and your son.
Yes.
But you got to take responsibility for some of that.
Or is there any way that we can monitor his alcohol use during the pendency of this?
Well, he's been on bond. What if we normally have something that we
I know he
do?
tells me he hasn't driven since he gets a ride everywhere he goes since the arrest.
It's not,
It's,
but he can also drink and wander into the hall, walk into the freeway, the
Yeah,
way he's been acting in the past.
I don't know that he's on
I
any
would,
other.
I'd recommend a scram device. That way
How
I
long are
mean,
we
the
asking
fact that
for? How much time?
I would,
I just want 2 weeks. Can y'all get
I'll do whatever I can in 2 weeks, Judge.
3 weeks? 3
Yes, sir.
weeks.
3
Uh,
weeks is fine, Judge.
But also, you've got an issue that you right now are required to have an interlock device in any vehicle, correct? All right. That's what I'm not going to change that.
Yes, sir.
Get a resetting for 3 weeks. Okay.